Good morning, good afternoon, and good evening. I welcome you to this Rule of Law, Justice, and Democratic Rights in Sri Lanka webinar organized by LAWASIA. And it is being, audience participation is from 32 jurisdictions. Friends, in this very important webinar, we will be discussing the concerns which have been arising in Sri Lanka of late and have been the subject matter of a resolution passed by the Human Rights Council as well. But LAWASIA wanted that our participants and our members learn more authoritative version and from different perspectives of what is happening in Sri Lanka. It is very important that all of us who come from the background of advocacy, being lawyers, from other professions, and individuals who are interested in the rule of law, to understand the full implications of what is happening in each of the jurisdictions in Asia Pacific. And we have a very eminent panelists today. They range from commentators who have been observing Sri Lanka for a long time from UK, and not just lawyers. We also have individuals who have done some excellent work in the field of human rights in Sri Lanka in terms of minority and gender rights. So we have a panel including a journalist to give a perspective on how these issues are perceived generally. So with this brief background, I will immediately introduce our first keynote speaker. He is a very eminent individual, Mr. Jeffrey Robertson, QC. He is founder and joint head of Doughty Street Chambers, United Kingdom. He had a very distinguished career as a trial and appellate counsel in Britain and in international courts, and as a UN appeal judge, the first president of its War Crimes Court in Sierra Leone. He is founder and joint head of Doughty Street Chambers, Europe's largest human rights practice, a master of the Middle Temple, and a former trustee of the Institute of Contemporary Arts. His book, Crimes Against Humanity, The Struggle for Global Justice, has been an inspiration for the global justice movement. His detailed biodata is published on the website, so we will rather hear him now because it's very distinguished.
Good afternoon from lockdown London. I'm talking to you, and I'm very grateful for your invitation to talk to you with a few introductory remarks to your important seminar on the rule of law in Sri Lanka, the state of the Republic of Sri Lanka, the state of denial, which is what the government is in and proposes to remain in. I've had the limited pleasure of dealing with a number of applications by torture victims from as long ago as 2009 and counting, and dealing with the government's claim that all is well, that they can go to domestic remedies in the Supreme Court, in the Human Rights Commission, and so forth. Preposterous claims that have been refuted by experts on the ground. So what is the state of denial at the moment, and what is being denied? Of course, we remember the 2009 massacre, the killing of at least 40,000, maybe many more, civilians by the Sri Lankan Army and Navy in their attempt to extinguish the Tamil Tigers. Well, they, to some extent, succeeded, and the Rajapaksa government was responsible for the war crimes that took place. They tried to cover them up, of course, by banning journalists, by banning NGOs, but all except the Red Cross, which they allowed in, purely because the Red Cross has this, I think, unsatisfactory ethic that they will never disclose what they find out. But gradually, what happened has been found out. Initially, caught on cameras, on iPhones, the bodies washed up on the shore, the rapes, the cruelty, the atrocities that were committed in the course of that massacre. And of course, the refugees, 300,000 or so refugees, who, some of them, made their way across borders and told what had happened. They told it to a committee set up by the United Nations Human Rights Commission. It was led by Maris Darussalam, the former Attorney General of Indonesia, and it told a terrible story of what had really happened behind the veil that the government had tried to set up. Let me read the conclusions of that committee just to remind us all. It said that the conduct of the war by the Sri Lankan army represented a grave assault on the entire regime of international law designed to protect individual dignity both in war and peace. It accused the army and navy of indiscriminate shelling of civilian areas and camps, abducting members of the local media, starving civilians in the conflict zone of food and medical supplies, as well as torturing captured Tamil soldiers and raping civilian women. It had justifiably harsh words too for the Tigers and their tactic of holding some of their own civilians hostage. But after a report as condemnatory as this, the Security Council had a duty under its responsibility to protect principle to follow up. It should have been referred, the situation in Sri Lanka, to the International Criminal Court prosecutor. But this was never a possibility because China stymied any action after the report was released, publicly threatening to veto any reference to the International Criminal Court. And that, of course, is one of the great problems of international humanitarian law, that countries like Sri Lanka don't sign up, don't ratify the ICC protocol. And the big five at the Security Council have a veto power, and they veto it whenever they think the action is going to disturb an ally. And that is what China did. That is what Russia does in relation to Syria. That is what America does in relation to actions against Israel. So we have a situation where international law, international criminal law, is not binding, is not effective. But nonetheless, in Sri Lanka, it was effective up to a point. The Rajapaksa government set up a lessons learned committee, although not many lessons were learned, and it went its draconian way. There was a dreadful case where they wanted to get rid of the Chief Justice, who'd shown some understanding and quite legally upheld a Tamil claim. And so they punished her with a bogus act of impeachment. And in my report for the Bar Association of England and Wales, I set out just how unlawful and indeed inappropriate were the impeachment proceedings trumped up against Mrs. Bandaranaike. But nonetheless, in 2015, there was hope. A new united government agreed with the Human Rights Committee that something must be done, that there should be no impunity in this country, that those who were responsible for the atrocities of 2009 should be brought to justice, that torture by police of Tamil should stop, that there should be mechanisms to counter the impunity that had reigned beforehand under the Rajapaksa's. So there was hope. And as the United Nations Human Rights Commissioner has said in her recent report, that after the investigation, the Jerusalem report was published, the government did show some signs of responsibility in reviving constitutional safeguards. But that didn't last long, because after 2019, when the defense minister of 2009, another Rajapaksa, came to power, those constitutional safeguards were watered down. First, says the High Commissioner, the safeguards of constitutional safeguards were weakened by giving the government more power over the judges. And then, of course, they came to nothing. In my recent couple of months or so ago, I had to deal with the claims of the Sri Lankan government that those who'd been tortured and viciously attacked by the security services should have some recompense, because in order to get to the Human Rights Committee for some redress, you have to show that you've exhausted domestic remedies. And in Sri Lanka today, there are domestic remedies to exhaust, although the government pretends that there are. This is what it says. It says that anyone can approach the Supreme Court and get redress. Well, that of course is untrue. As you probably know, there's a 1-month time limit, which those who've been tortured, who've had to hide or go abroad, cannot possibly meet. So the Supreme Court is not an effective mechanism for ending impunity or for providing redress. And then it says, well, we've got a committee against torture. You can go there. But of course, that remedy is practically unavailable. There have been hundreds of claims made under it, but it's resulted in only 11 cases, 8 of them being acquittal. And pursuing a claim takes years. And unfortunately, there are credible reports of reprisals against those who do bring a claim. So that mechanism for redress is not available. And then there's a fundamental, the National Human Rights Committee we've got, says Sri Lanka. It's mandated to investigate complaints into human rights violations. However, it never supports the victims, it's corruptly appointed, and it only has power, even if it exercised it, which it doesn't, to order conciliation and mediation. No power to order compensation, and only non-binding recommendations. It's not legally independent. So the three mechanisms that the Sri Lankan government pretends to the Human Rights Commissioner are effective and adequate, simply are not and can be proved. And I have filed a number of expert reports that show that these mechanisms are not working. So at the end of the day, and I think rather than summarize them, I will read you the conclusion of the Michelle Bachelet only 6 weeks ago, when she reported this about Sri Lanka to the Human Rights Commission. And I think she summarizes the evidence in this way. Nearly 12 years from the end of the war, domestic initiatives for accountability and reconciliation have repeatedly failed to produce results, more deeply entrenching impunity, exacerbating victims' distrust in the system. Sri Lanka remains in a state of denial about the past, with truth-seeking efforts aborted, and the highest state officials refusing to make any acknowledgement of past crimes. This has direct impact on the present and the future. The failure to implement any vetting or comprehensive reforms in the security sector means that the state apparatus and some of its members credibly implicated in the grave crimes and human rights violations remain in place. The 2015 reforms that offered more checks and balances on executive power have been rolled back, eroding the independence of the judiciary and other key institutions further. The beginnings of a more inclusive national discourse that prompted greater recognition and respect and reconciliation with minority communities have been reversed. Far from achieving the guarantees of non-recurrence promised by Resolution 30/1, that was the 215 resolution, Sri Lanka's current trajectory sets the scene for the recurrence of the policies and practices that gave rise to grave human rights violations. So rarely do you get a stronger indictment of a member country than that I've just read, proposed and put by the United Nations Human Rights Commissioner. She went on, the High Commissioner is alarmed that the space for civil society, independent media is rapidly shrinking. She wants all forms of surveillance and intimidation and harassment against human rights defenders, lawyers, and journalists ended. And she concludes by saying the Human Rights Council therefore is once again at a critical turning point in its engagement with Sri Lanka. Twice before, the Council has lent its support to domestic accountability and reconciliation initiatives, culminating in the 2015 Resolution 31. The government has now demonstrated its inability and unwillingness to pursue a meaningful path towards accountability for international crimes and serious human rights violations, and signaled instead a fundamentally different approach, which threatens to deny victims their rights to truth and justice, and further entrench impunity. So that is the situation that the UN mechanism for human rights redress has come to. The Sri Lankan government will not obey, will not abide by human rights principles. It's the end of the road. Sadly, the United Nations will not act. The Security Council is poleaxed. At the moment, the threat of a veto from China, particularly, stops the Security Council taking any action. Of course, we continue with the International Criminal Court, but it doesn't, because Sri Lanka, of course, hasn't ratified the ICC statute. So, of course, that is not available other than by a reference from the Security Council, which will not refer Sri Lanka. Where do we go from there? Well, we try, of course, bringing cases to the UN Human Rights Committee, a tribunal of 18 experts who examine the situation and can issue verdicts. But they are not binding. They're very helpful as legal verdicts, but they're not binding. ASEAN has an organization to look at human rights. It doesn't do very much. Myanmar and Vietnam and so forth are members, and it never seems to grasp the nettle. So international law is failing. But among the recommendations, and of course, the Human Rights Commissioner this year made a number of recommendations about Sri Lanka, but most of them were based on these possible international law remedies, which are no practical use because they're not binding. But it called upon the government to remove perpetrators from their positions of power, from their roles as diplomats and so forth. It called on them to order the military to stop, and the police to end torture and other violations and stop reprisals against human rights defenders. Well, of course, the government will pay no notice to that. And they did, and they wanted a moratorium on the use of the Prevention of Terrorism Act. That won't work because the government won't stop using it against human rights groups. There was, among these many recommendations which the government will pay no attention to, there was rather hidden a call to explore possible targeted sanctions, such as asset freezes and travel bans against credibly alleged perpetrators of grave human rights violations and abuses. Now, this is something that I want to say a few words about, because it calls into operation what are termed Magnitsky Laws. Now, they are targeted sanction laws, and their great attraction, increasingly, is that they are enforceable. Unlike international law, they take principles of human rights, definitions from international law, but they are exercises of national laws. They called Bagnitsky after a Russian lawyer who was imprisoned back about the same time as the destruction of the Tamils in 2009. He was imprisoned in a Russian prison. And what happened to him was pretty much what happened to George Floyd. He was George Floyd without the cameras. He was beaten to death in a Russian prison, and his employer, a man called Bill Browder, took up his case, wanted to expose and punish all the people, lickspittle judges, negligent doctors, who were in corrupt policemen and law officials who had been responsible for his death. And in 2012, he convinced John McCain and then President Obama to introduce the first Magnitsky Act, which provided targeted sanctions against those involved in serious human rights abuses. And that was followed by the Global Magnitsky Act in 2016, and then followed in Canada, and then in Britain last year, and finally in December last year by the 27 European Union countries. So there are now 31 democracies in the world that have targeted sanctions, Magnitsky laws, to, I suppose, name, blame, and shame the perpetrators of human rights atrocities, and as well, some cases, as serious corruption. So this at last provides a remedy for victims whose perpetrators have got money, whose perpetrators have got positions abroad. The United States has used its Magnitsky Act against certain Sri Lankan generals or people responsible for the killings in 2009. What it does, of course, is an exercise by open societies, by parliamentary peoples, of their power to ban, to exclude, to freeze assets of bad people who hold assets. But more importantly, as the sanctions recently on China over its dealings with the Uyghurs have shown, it also deters companies in the West from doing business. All the fashion houses of the West have now refused to source their cotton from Xinjiang province, where it is picked by slave labor of the Uyghurs. So this is a new way of implementing human rights rules and a form of punishment for those like the leaders of Sri Lanka who go ahead. And sometimes it hurts them. Sometimes, if they've got commercial contracts or their ill-gotten gains go through Western banks, it can cause them great embarrassment. It can end their opportunities to make money from their human rights abuses. It's there was a recent case where the US sanctioned Carrie Lam for helping to destroy democracy in Hong Kong. And she complained bitterly that her credit cards wouldn't work, even those drawn on Hong Kong banks. And she had to take her salary, 700,000 US dollars a year, comes to 5 million Hong Kong dollars. She had to take it and keep it in her home in notes, and it was cluttering up her house. Well, that gave a laugh to her victims on social media. But for most, for others, it can be a very serious sanction. And it's very useful. I think a number of Sri Lankan politicians, particularly those with investments in Australia, should be made subject to it. It's very good for what I call the train drivers to Auschwitz, the lickspittle judges who sentence enemies of the state on orders, the doctors who oversee torture sessions and the like. And it means that an increasing number of democratic countries, Japan, actually, its parliament is considering joining the Magnitsky movement, but it does mean that an increasing number of democratic countries are denying their banks, their businesses, their schools, that's important, and universities, and their hospitals to families who are implicated in human rights abuse of one sort or another. And I think this is a fertile area for those of us concerned with human rights abuses in Sri Lanka to explore. At the moment, there is a Magnitsky bill resulting from a report of a parliamentary committee that's about to go into the Australian Parliament. I hope it will certainly be debated. I hope the law will pass. But it seems to me that for the moment, while international law is ineffective, unfortunately, in so many human rights arenas, the Security Council will not act, the Human Rights Committee decisions are not binding. In fact, I think only 30%, recent study showed, had been implemented. We must look to our own national laws, and we must set up Magnitsky lists of people who, in effect, are ostracized, are named and blamed, and who should have no connection. All these military, ex-military officers whom the Sri Lankan government is appointing as attachés to its foreign embassies must be declared persona non grata because they're put on Magnitsky lists. So I hope Australia will join the Magnitsky movement this year, as 31 other democracies have. I hope that Japan will join it. I have hopes that LAWASIA will encourage Singapore and Malaysia and Taiwan and other countries that want the rule of law to join. And if you want a description of how Magnitsky laws could help in ending impunity in Sri Lanka by threatening those who are responsible for turning it into a state of denial, then I can offer my book, which is published next week, which is, I think, the first book on this new Plan B for human rights, as I've described it. It's called Bad People and How to Be Rid of Them. And it describes this new form of ostracism. The Romans got rid of their people they regarded as bad, but this goes further. It does not only name and shame them, but it causes them embarrassment. I mean, judges, doctors who do bad things, they all love going to Europe and traveling to Australia. They like sending their children to its universities. They like going to the beach even, and sending their parents to its hospitals. I think the way to perhaps persuade them, because international law is faltering, is to ban them, to take their assets, and to stop them entering into transactions with companies and people in the West. That is the way forward at the moment, the only way perhaps to prove to them that the game isn't worth the candle. Thank you for listening.
Thank you for giving up patiently listening to a long but authoritative talk from the point of view from where Geoffrey Robertson comes. It was a pre-recorded speech, and since the webinar time would have been 4 a.m. in London. The very short comment I will add here is this, that LAWASIA as a regional organization has been engaging with the members like Sri Lanka for the longest time. And we, including myself from LAWASIA, went to Sri Lanka during the most intense phase of civil war as well, before 2009, where when we went from airport to Colombo, there were all posts lined with bazooka wielding cops, where any errant vehicle could have been targeted. But there has to be a journey once the civil war or once so-called terrorism ends to the rule of law, and that journey goes through reconciliation. And for reconciliation, there are models, but not every model is fit for all, because those models have to emerge organically from each jurisdiction. And that is where organizations like LAWASIA, which have ear to the ground in the region, and this kind of intensive interaction with the direct stakeholders, its role comes into play. So after that, I will now introduce our next speaker, who is going to provide introductory remarks, Mr. Marwan Makan Maka. He is Asia Regional Correspondent for Nikkei Asia, and he's based in Thailand and Sri Lanka. He had reported from the front lines of conflict in Sri Lanka during his 27 years of illustrious career. He has reported from many jurisdictions, from conflict areas, and he gives a deep insight report on human rights issues. And that's why he's very, very pertinent to have him here and make introductory remarks on this webinar on the topic on which he has been reporting extensively. Again, his full bio is available on the website. Marwan. Over to you.
Thank you, Prashant, and greetings from Bangkok. It's my privilege to be a member of the distinguished panel to address a rather weighty subject of rule of law, justice, democratic rights in Sri Lanka. I've chosen to focus on the outcome of, or what happened in Geneva and the outcome and its implications. It should be clear to anyone who followed the headlines from Sri Lanka last month that the country has continued in a downward spiral on the stage of global affairs. The yardstick that reveals this trend is the number of votes the government was able to muster over a resolution at HRC in Geneva. It succeeded in getting only 11 of the 47 members of the commission. This is quite a diplomatic fall from grace, as it raises questions if the country can sink even lower at the HRC. To understand Sri Lanka's predicament, one has to go back to 2009, the year that we have already talked about and mentioned, the year when a bloody 30-year civil war came to an end. That year, against heavy diplomatic odds, Sri Lanka convinced 29 countries to back its case. But that high water mark in diplomatic lobbying, as we now know, was to be short-lived, as resolutions in subsequent years revealed. In 2012, for instance, international support fell by half to 15. By 2013, only 13 countries stood by Sri Lanka. And by 2014, as the then President Mahinda Rajapaksa was rounding off his second term, international support at the HRC dropped to 12. This scorecard of Sri Lanka and Geneva is open to many interpretations. For me as a journalist, it has been useful to help engage the trajectory of Sri Lanka's post-war history and how that is perceived internationally. It has also served as an entry point to understand what the national mood is on the human rights front and where the political class sits on issues such as justice and reconciliation. This, interestingly, has been reflected with ample fervor in the debates spread across the Lankan media around periods surrounding human rights sessions. But if you step back from the noise, you will be able to detect elements of a political ritual taking place. One can even break it into a pre-Geneva session and a post-Geneva session. In that context, colorful expressions have surfaced and flavored the vocabulary of discussing the Geneva situation. Some of these expressions I discovered have drawn from local situations and some from world literature. One well-known Sri Lankan media personality, for instance, kept referring to the months leading up to Geneva as the Ides of March and warning the country. The sentiment among ordinary people is equally significant. They have enriched the discussions, and that is how I picked up this particular expression about the HRC as a sword of Damocles hanging over the Sri Lankan state. Some of these thoughts were shared in conversations I had when I last wrote about Sri Lankan human rights situation in Geneva. This was late last year. And the impression I came with after some of these conversations was that human rights issues and Geneva have now become a constant in Sri Lanka's contemporary political life, and it may easily qualify in second place after the national elections as a useful barometer to measure the Lankan political winds. But let me expand on that point, because the Geneva sessions have another dimension that is as relevant for those of us who follow Sri Lanka's political twists. They provide guidance to track where the country stands in its commitments to deliver on rule of law, justice, and democratic rights, which is the theme of today's webinar. For observers of Sri Lankan affairs, the text that emerged out of Geneva has opened up few new storylines to consider. One that should keep journalists busy is the language for an accountability process to achieving post-war justice. The relevant section says that this new international effort will be mobilized to, quote, collect, analyze, and preserve evidence of gross human rights violations and international crimes. This should make uncomfortable reading for those who are involved in war crimes and human rights atrocities. Some of the names implicated in such abuses are already in the public domain. It is very likely that now, with an evidence gathering mechanism about to take shape, more names will be added to that list. So bit by bit, what has appeared not possible in Sri Lanka because the government was reluctant or justice systems was incapable is now taking shape. But the more headline-grabbing accounts are likely to emerge from other passages of the Geneva text. It is the section that has encouraged countries hearing cases against Sri Lanka's alleged war criminals to consider their own respective courts and jurisdictions. These provisions have pushed Sri Lanka to join the ranks of nations with brutal legacies of political oppression and ethnic conflicts in Latin America, Africa, and Asia. It may be worth recalling that some of the governments from those countries has to muster sufficient diplomatic capital to deal with their own citizens who were accused of war crimes and were being targeted by human rights activists and lawyers. The latter wanted the former to be tried in foreign courts under the principles of universal jurisdiction that had come into existence. In light of Sri Lanka's dismal voting record in March, this is surely going to be another test of how far the country's diplomatic capital can be used. Such a turn in Sri Lanka's human rights narrative comes down to this for those who have committed war crimes. Henceforth, they may have to give serious thought to which countries they plan to travel next time. It will not be business as usual. There's a growing list of examples that help to illustrate cases of serial human rights abuses who are in foreign countries as free men. Yes, the violators happen to be all free men, being arrested for war crimes and grave human rights violations. The Indonesian dictator Suharto's name comes to mind among the early examples of this context. He was on such a wanted list for his oppressive record during his autocratic rule of 32 years. The terror he unleashed resulted in massacres of up to 500,000 citizens, yes, 500,000 people, according to conservative estimates. But after he lost power in 1988 and his health weakened, the former strongman of Southeast Asia feared traveling to European countries for medical care. The reasons, according to human rights groups, was that he dreaded being arrested on foreign soil. So he stayed at home and he avoided becoming an international story. But the one who did create a media storm and someone who is worth recalling in light of the theme I've chosen to focus on today is the imperious and arrogant Augusto Pinochet. For those unfamiliar with the name, he was the former dictator of Chile. He was arrested in London after a British court accepted a case against him by a Spanish jurist. The moment was celebrated by human rights campaigners for the precedent that the British courts had set. ending the concept of sovereign immunity that had given war criminals and tyrants the freedom to travel without fear of arrest. It marked the arrival of the universal jurisdiction as another means by which to go after the worst human rights violators. And the world got the Pinochet precedent as a result. In fact, it was only a few years later, after this issue dominated the headlines, that I first came across the name of Ricardo Miguel Cavallo. I was working in Mexico at the time and had been assigned to cover human rights. The beat included stories of the men who had been involved in the former oppressive regimes of Latin America. Some of them had fled to Mexico like Cavallo. Others had gone to other safe countries. Cavallo had been a military officer in Argentina before that, when it was ruled by a junta during the years of the Dirty War. He had arrived in Mexico later and had remained under the radar as a free man for many years, working in Mexico's National Registry of Motor Vehicles. But then his cover-up ended. He was arrested in the Caribbean resort, coastal resort of Cancun. The Pinochet president had finally caught up to him. Yes, he was indicted under that principle, affirming that the idea of universal jurisdiction was spreading across countries. Mr. Robertson, who spoke before me, mentioned the Magnitsky Act and the Magnitsky movement. This is a further development to the groundbreaking universal jurisdiction principles. Stories like Cavallo will continue to hold and be told because they help to advance the cause of justice and accountability. The likelihood of Sri Lankan names joining that list has increased after the Sri Lankan government's diplomatic debacle in Geneva. And if that was to happen, those of us who are observers and reporters of the country's political life will have new areas of inquiry to pursue. Thank you.
Thank you, Marwan, and you have completely justified the trust the organizers put in you to bring you on as an introductory speaker and to bring your insights as a journalist. You have put in the whole perspective from emerging from Geneva, and by giving a very short perspective on how these things have been taking place, especially qua the rule of law, crime against humanity, and reconciliation, and all the issues. And it is very important, and here, in a very brief remark, I wish to highlight. See, when there is a bloody civil war, 3 decades, and it has been put an end to, there are costs. But there are accountabilities as well. And once the war ends and a democratically elected government takes over, its primary responsibility is to uphold the Constitution, to uphold the rule of law, and it has to govern all and provide confidence to all. Because though the elections bring a majority government in place, but the constitutions and other international and domestic legal and constitutional frameworks, they impose a duty on the regime to be the regime for the entire country and not just those who voted. So they have that responsibility, and responsibility of those on power is much more than the others. So that's how we are discussing this today, because that is what comes from Sri Lanka's own constitutional framework. And these are the concerns which emerge from the international human rights law for any country to be counted as a country which is recognized as a democracy based on rule of law in the Committee of Nations. So now we have a very eminent speaker, who comes from a background which is very crucial to this seminar. She, Ambika Shakuntanathan, she had been for 5 years member of the Human Rights Commission of Sri Lanka from 2015 to 2020. Presently, she is an Open Society Fellow for the year 2021. She has been a consultant to the Office of the High Commissioner of Human Rights of Sri Lanka, on Sri Lanka, and she has very illustrious career in the field of human rights. Her full bio is available on the website. So now I will request Ambika to make her presentation.
Thank you, Prashant, and thank you to the organizers for inviting me. So I think for the purposes of today's session, where we are interested in the role of law in protecting human rights, I will try to set a bit of context. I think when discussing the role of law in protecting human rights, we have to first acknowledge that the impact of law on individuals and communities is shaped by factors such as their ethnicity, religion, privilege, socioeconomic status, and socio-political context. So what is the current socio-political context in Sri Lanka? Like in many other parts of South Asia or even globally, in Sri Lanka, we have a majoritarian government and see the resultant surge in ethno-nationalism and communalism. And in a way, this is not surprising because the Sri Lankan state has remained largely the same, despite the change of government. So it's a majoritarian state driven by Sinhala Buddhist nationalism, in which the discrimination of minorities has in a way been normalized. As Mr. Robertson said, in Sri Lanka, civil society organizations and civic space, both of which are very important and integral to holding the state accountable, particularly with regard to human rights violations, have been subject to different levels of curtailment during different regimes throughout our history. So for instance, even before 2015 and also currently, we find that civil society organizations in the North and the East are subject to surveillance, intimidation, interrogation by security agencies who visit their offices, request for information, etc. But most concerning is the labeling of victims, dissenters, and particularly those who call for accountability for human rights violations, especially for violations that took place during the war, as traitors, anti-national, and even terrorists. Surveillance and intimidation of civil society didn't entirely disappear, even during the good governance regime from 2015 to 2019. The difference, however, is that during that time, it wasn't widespread or common. And at that time, civil society felt they could report it to an independent human rights commission without facing reprisals. Although the commission's interventions resulted in the immediate cessation of such extralegal action, the oppressive and extralegal structures and processes remained intact. So the failure to address these oppressive and discriminatory structures and systems has undermined human rights protection in many ways. For instance, state violence against minorities, persons thought to be a threat to the state, such as journalists and human rights defenders, has been the permanent normal in Sri Lanka for decades. Not surprisingly, historically, the state has been hostile to holding any state official accountable for rights violation. So an example is police violence, which is prevalent all over the country. It is systemic and deep-rooted, as illustrated by the 483 complaints of torture and 462 complaints of arbitrary arrest and detention received by the Human Rights Commission in 2018, and the 400 complaints of torture and 775 complaints of arbitrary arrest and detention received in 2019. Now, this is just the tip of the iceberg because most people don't report and only a minority actually make these complaints. So as I said, where state violence is concerned, the focus is often only on the individual officers. Yet the acts of the individual police or military officer take place within a system that is deeply rooted in impunity. The extent to which impunity is entrenched in the system was identified even by a 1947 report of the Police Commission, even as far back as that. We do have a Convention Against Torture Act that criminalizes torture, but we do not know the exact number of convictions under the act. The other issue of concern is increased and rapid militarization, not only in the conflict-affected North and the East, but in the entire country. Since the regime change in November 2019, the president has been using the Public Security Ordinance to call out the armed forces to maintain law and order, even when there is no emergency or crisis that requires it. Military officers have been appointed to positions in civil administration. They are leading the COVID-19 response and even conducting training for public service officials. The militarization of civilian space is also not new. It began aggressively during the first Rajapaksa regime, and even during the good governance regime after 2015, there was no effort to demilitarize. If at all, I would say there was a temporary partial freezing of militarization, which has now resumed with vigor. So in this context, the new regime that came to power in November 2019 set in motion visible and invisible processes that are changing social value systems and public perception in ways that undermine democracy and respect for the rule of law. An example of a visible process is the enactment of the 20th Amendment to the Constitution, which undermined the independence of institutions such as the judiciary and the Human Rights Commission of Sri Lanka. It strengthened the powers of the executive and undermined checks and balances. But more insidious are the unseen or the invisible processes. An example of this is the president's instructions to public officers in September 2020 to take his verbal instructions as circulars. His February 2020 statement that it is important that the judiciary does not interfere needlessly in the functioning of the executive and legislative branches of the government illustrates disdain for legal processes and even the judiciary. So what is the outcome of this? Legal systems and processes have become tools to be employed or dispensed with at the executive or the regime's convenience. This has resulted in selective application of the law. The law is weaponized as a tool of repression, and the marginalized and powerless are subject to discrimination and violence. An example is the Prevention of Terrorism Act. The Prevention of Terrorism Act, or PTA as we call it, allows for arbitrary arrest and detention for 18 months without being produced before a magistrate. The most recent arrest using this law is that of a Muslim poet, Agnafna Jazim, who was arrested due to a book of poetry, which supposedly they say promotes extremism, but from what we can see calls for an end to extremism. The PTA also creates room for torture, as illustrated by the Human Rights Commission's study of prisons, which found that in the study sample, 84% of male PTA inmates stated they suffered torture following arrest. An overwhelming majority of these people, 90%, said they were made to sign confessions after torture. More recently, regulations on de-radicalization were issued under the PTA. Now, these are very similar to regulations issued in 2011 that allowed for rehabilitation of alleged former LTT members, but in practice actually resulted in gross human rights violations. This time, these regulations appear to target the Muslim community. They enable arrest and detention, contrary to the procedure set out by the law. They permit investigations to commence after arrest, which deprives a person of being informed of the reason for the arrest. And they also violate a person's right to fair trial, because they deem a person guilty and require that person to be subject to rehabilitation without even a trial. Moreover, they can prevent a person from accessing legal representation, perpetuate ethno-religious stereotypes, and encourage racial profiling. And the most recent move in instrumentalizing the law to curb dissent and criticism of the government is the proposed law to curb fake social media posts, including, supposedly, posts that portray the country negatively. Now, this law, they say, has been modeled on the Singaporean Protection from Online Falsehoods and Manipulation Act. So what do we have now? We have a government which seems to have little respect for the rule of law, due process, or the human rights of its citizens, but at the same time instrumentalizes the law as a weapon to stifle dissent. In Sri Lanka, like in many other countries, all of us, lawyers and human rights advocates, often look immediately to the law as a solution. Law is often portrayed as a neutral tool that we can use in the process of resolving a human rights issue or a social issue. But as Radhika Kumaraswamy states in her analysis of the rule of law, despite its pretensions of objectivity and neutrality, is in the final analysis also a system of power. It includes and excludes people, it disciplines and punishes. The other element to factor into the equation when we consider the law as a main means of protecting human rights is the institutions that will be implementing the law and functioning as the oversight bodies. In general, in Sri Lanka, it is accepted that our public institutions are politicized. So can we trust these institutions not to abuse the law? Finally, as human rights defenders working in a complex and volatile context, it might be useful for us to reassess our legal reform initiatives, since litigation and legal reform has yielded mixed results. Should we revisit our strategies and perhaps frame issues and strategies differently? As long as practices and institutions that embody and perpetuate injustice remain, the impact of legal reform initiatives will be limited because injustice is institutionalized in the social, political, legal, and economic structures. For instance, violence against minority communities has taken place for decades. This points to the need to move beyond formal equality and focus on substantive equality. Since context is very relevant to eliminating systemic and institutional discrimination, we should focus not only on equal treatment by the law, but also on the effect of the law. The most difficult change to achieve is actually not political change or even reforming laws. The real challenge lies in changing mindsets, replacing regressive value systems and reversing the damage done to progressive value systems. Thank you.
Thank you, Ambika. You have brought in a perspective from a person who has worked so extensively in the field of human rights and also been part of the formal institutional framework as well. And what you have highlighted most importantly is the majoritarian bias of a democratic setup, which ultimately makes rule of law and equality into formal legalistic structures rather than substantive justice and equality oriented structures. And unfortunately, this is not something which, you have shown that it has been prevalent in Sri Lanka for a long time. Has come in a more exasperated form now, but it is catching on throughout the globe. That space is shrinking even in the jurisdiction I represent, which is India. And even if you look at places in the West, last regime in the United States, the impulse behind the entire Brexit exercise in UK, all these are parts of the same impulse. And that is the real challenge for all of us who believe in substantive equality, in inviolable principles behind it, and the rule of law. How to bring the democracy back to the very foundations on which it is erected, and not just become a political system which justifies its existence by majority in terms of elections. So that is the real challenge. Thank you very much, Ambika. And now we have, our next speaker is the one who has come not just from grassroots, but has a lived experience to share. And, when we talk about 30-year civil war and LTTE and the aftermath of it, it is not just, something which is Tamil versus Sinhala. What happened to the minorities? Were LTT also responsible in a way for perpetuating some of its atrocities during the Civil War, whether they were fighting for equality or they were also perpetrating not just against majority, but certain things against the minority as well. So she comes from the northern part of Sri Lanka, Mannar, and she's co-founder of Mannar Women's Development Federations and Women's Action Network. And as I said, that challenges faced by Shireen in her own experience of being forcibly evicted and displaced, along with all the members of her community from the north by the LTTE in 1990. That is what laid the foundation of her activism. She has been internationally recognized in 2004, John B. Kroc Institute of Peace and Justice elected Shireen as one of the women peacemakers, and she has won many awards, including the 2008 Voices of Courage Award by the International Rescue Committee's Women and Refugees Commission for her work. And in 2011, 5th International Women Peace Award under the category of Public Engagement for Peace or Justice. Again, her resume is on the website, and she brings a very important perspective on the table in this entire debate on rule of law, justice, and democratic rights in Sri Lanka. And just before bringing her on, I want to say I have a background which has been provided by Sri Lanka. But our friends tried to download and have it, but it did not work. Perhaps it is symbolic. So, Shireen, over to you.
Thank you very much, Prashant, and everybody who has put together this conference. And I am here to talk about mostly the current situation of the minority religious community. But as you pointed out, the Muslim community during the civil war, particularly in the north and the east, was affected by both the government and the LTT as well. To date, they are struggling to find justice for injustices committed at that time. At the same time, right now in the post-war context, both the evangelical Christian minority and the Muslim community has been facing continuous violation. As keynote speaker spoke that Sri Lankan government is denial. It's not only in denial, it's overtly continue to commit violence against ethnic minority and religious minorities. And in that context, I'm going to speak a little bit more about what Ambika talked about on the ground realities and what is happening, particularly, like a combination of various governments. It's not only the current government, but also the previous governments. Now, the Muslim community has become the target in the post-war context because the Rajapakshas wanted a common enemy, and that has been the policy even the last election. If you carefully look at the Viatmaga movement that supported the president came up with one country, one law. Particularly, they have played not only the war victory and then Geneva accountability process as a card to win the constituency, but also whipped up the anti-minority sentiment, particularly the anti-Muslim sentiment. In that context, it was very interesting that President in his inauguration speech talked about how he has been elected by Sinhala Buddhist, and his inauguration happened not in usually it happens in the Independence Square, but it happened in Anuradhapura, which is central to Buddhist heritage in Sri Lanka. And he continuously talks about Sri Lanka as not only Sinhala only, that is the core to the minority conflict in the country, but also Buddhist only now. President Svyatmaka movement very overtly talks about one country and one law. So there have been quite a lot of attacks on the Muslim community. It's mob violence to like various forms of attacks on the Muslim community. Name it, it's their businesses, banning halal food, attacks on professionals, as Ambika pointed out, arresting people and framing charges later, and also like takeover of cultural sites and where the Muslims and minority religious community live in various parts of Sri Lanka. Very interestingly, while the country was under lockdown, the defense secretary, the current defense secretary, who is also alleged war criminal on the OISL report, appointed under president's order an immediate establishment of a naval contingent to protect the Buddhist Pothuwil Muhudu Mahavihara temple and its land. This land is about more than 100 acres, and where the Muslims and Tamils live there, and so they are in the process of getting evicted. So it's identical like what happened to us during the war. That like various parties try to do this ethnic cleansing in the name of religion or ethnicity and various forms of militarization. And President also, as Ambika pointed out, has appointed various task force. This was allowed purely because of the 20th Amendment. Also, President's overtly exercising his power, taking away the only safeguard that is in the Constitution is the 13th Amendment to the Constitution. So what the president is doing is that provincial level of the ruling, the devolution of power. Now the president is concentrating that power in the form of appointing task force where the military men and his family members and various Sinhala Buddhist monks are in charge, and also appointing governors. So basically, to many of us, that 13th Amendment to the Constitution, which is a minimum that the minority communities, particularly Tamil communities, has got, is going away. The appointment of Heritage Task Force in the Eastern Province, the president has appointed only Sinhala men, mostly Buddhist monks and the military, to identify the Sinhala heritage sites and establish the temples and the community out there. Mostly, even though it has been appointed as East, but right now this particular task force led by the army commander has been going around the country and identifying ancient Hindu temples and Muslim community areas, and they are claiming this as a Buddhist cultural sites and taking over. Then the other development has been that the Sri Lanka previously, 10 years ago, had various ministries for religious affairs, but all of it is now has come under Buddha Sasana ministry. Previous government at least had state ministers to look after each religious affairs, but now it is Buddha Sasana, and the prime minister is the minister of that Buddha Sasana. All other religious affairs have come under that. And very interestingly, currently this particular ministry has been looking at issues pertaining to the Muslims and also the evangelicals. Now, say for example, cow slaughter banning has been discussed, niqab ban, Arabic script is under scrutiny. More recently, they have seized 15,000 of Quran translation. These Qurans are, this is very, very clearly Quran. It says in Sinhala as well, but they have seized all the Quran that the particular group of people have imported from India. And also Madrasa reform. Another one that is very close to my heart is Muslim Marriage and Divorce Act, which we have been, it's an archaic act that we have been asking for reform in par with the Article 16 of the Constitution, sorry, Article 12 of the Constitution, to equalize the Muslim women's rights to other women in this country. But now they wanted to repeal the MMDA, Muslim Marriage and Divorce Act. And then there is a circular that came in October 2008 under current Prime Minister, but the former President Mahinda Rajapaksa, which regulates new construction of places of worship. So they are using this very selectively, only to scrutinize the Muslim and the evangelical community. More recently, during the pandemic time, most of the evangelical churches have been visited by the Sri Lankan intelligence officers, and they have been asking their congregants detail, also newly converts details. There have been 184 incidents of intimidation and 276 incidents, the state officials perpetrating violence against evangelical Christians have been recorded. Two of the lawyers who have been talking about have been targeted, and there have been one particularly have been targeted by the former president, Maithripala Sirisena. And this particular lawyer has been told if he doesn't shut his mouth, his bar association membership will be cancelled. So the evangelical have been basically shut because they are very scared. And now the Muslim community is under heavy pressure. And in the post-Easter suicide attack, there have been about that killed about 265 persons. Yesterday was the second anniversary of this bloody attack. However, over 300 Muslims, among them are about 20 odd women and infants. 3-4 infants have been locked up in very pathetic prison condition. And Ambika pointed out this radicalization cassette that has will become an addendum to the already draconian PTA. These people will be sent to rehabilitation without much oversight of magistrate. It's very scary because the real culprit can go free, and then many of these innocent people, some of them didn't even have any direct connection or affiliation to this particular group of people called National Tawfiq Jamaat. And Sri Lankan government has also more recently come up with 11 Muslim organization banning them. It includes Al-Qaeda and ISS and some charitable organizations. So that they are showing that Sri Lankan, some of the charitable organizations are equal as Al-Qaeda and ISS. And also there are ban on lots of people, Tamils and the Muslims. Over 500 of them have been banned. Organizations that worked, many of the Tamil organizations worked on Geneva processes. And also, if you carefully look at these over 50 odd Muslims who have been added, many of them are innocent. The hardcore ones are not on this list. So very interestingly, only day before yesterday, the Attorney General Department asked for trial at bar for a few people who have been named as or indicted in the Los Angeles court for the Easter attack. And also there are lawyers, there are civil society activists, Facebook activists who have been locked up. And very interestingly, Sri Lankan government has been using not only PTA, but the ICCPR Act, which Sri Lanka has enacted, and it has been abused against the minority religious community when they talk back or they counter the current violation against minority community. I will leave with that. Thank you very much.
Thank you, Shireen. Your perspective is very important to us, and there is a continuum of what Ambika said. From your perspective, you have described how deep-rooted these things are when it comes to minority. And again, I am tempted to say that this rise of strong leaders, democratically elected, who speak to their majorities. See, in democracy, you have to speak to a majority to get elected. But speaking to a majority to the exclusion of others, to the specific professed exclusion of others, is what is the most detrimental and destructive of the rule of law. And unfortunately, that impulse is spreading. It has taken deep roots in certain jurisdictions, and there are signs of it, flourishing and taking roots in other jurisdictions. as LAWASIA, as a community of lawyers and those who defend human rights and rule of law, I think this is of very, very deep concern to all of us. And we should be identifying these signs at the threshold and try to do whatever is in our power to do, at least by creating public opinion. Now, in this context, again, our next presentation by Viran Korea, who is a very reputed lawyer who has done his LLM on constitutional law, has worked with Attorney General's office, and basically has practiced constitutional law in courts. And the concern he's bringing on table is in a way core of this session, because ultimately when any of the challenges which have been highlighted so far emerge, whom you look to for recourse? To the judiciary. And if judicial appointments do not guarantee independent and robust individuals to occupy that very sacred position, which is central to the enforcement of rule of law, that is the position which is central to imbue the spirit of substantive equality, substantive justice into the words and text of law. So how those appointments are made, how that institution functions really brings a difference. And if that is compromised, that is where dilution takes place. That is what strikes at the core of the rule of law. And that becomes the real problem for any country which is facing such a scenario. So, Viran, over to you.
Thank you, Prashant, and thank you, LAWASIA, for organizing this conference, another great initiative of LAWASIA. Let me be quick. I wish to focus on a very narrow area given the constraints of time, although I do have numerous perspectives to share on much of what has been shared by the other eminent distinguished speakers today. I wish to focus on, at the outset, before getting on to what Prashant indicated I would be touching on, I would like to touch on something that is a recent development that is a matter of some grave concern, because it impinges on the ability of the judiciary and the law enforcement system, by that I mean the police service, as well as the Attorney General's Department as the prosecuting arm of the state, and of the private bar, who are officers after all of the court and nothing less, who assist in ensuring that the rights of all who are arraigned before court are protected. Now, it goes without saying that there is no rule of law without a legal and judicial system that can function without being subverted. And I wish to make a point at the very outset, at a recent development in terms of which we observe that there is a tendency to resort to appointment of commissions of inquiry as a means of subverting the requirement of having any allegations tested by a proper process as is contemplated by the normal legal and judicial system. Now, recently, I will exemplify this in this way. A commission of inquiry was appointed under the Commissions of Inquiry Act of 1947, soon after the current president assumed office. And the mandate that was given to this commission was to inquire into and report on allegations of victimization of public officers, of employees of public corporations, members of the armed forces and police during the period from January 2015 to November 2019. Which is basically the period during which the previous government held office. Now, the composition of this commission of inquiry, it's headed by a retired Supreme Court judge. There is also a retired Court of Appeal judge and a retired Inspector General of Police. They began to hold their sittings, and serious problems began to surface in the way in which this commission of inquiry functioned, or perhaps I should say malfunctioned. Now, let me explain what I mean in very brief and clear terms. To begin with, the Attorney General himself raised an objection to the Commission of Inquiry entertaining complaints addressed by various people against whom there were serious criminal charges. The Attorney General looks into reports that are given by relevant investigators, assesses it, and those officers decide whether or not there is material to establish a case beyond reasonable doubt. That is a professional legal assessment by the official bar. Certain cases had been filed on that basis. And some of those people, knowing that this commission has been set up, perhaps they knew that it might lead to something, decided that they will make certain complaints. So they made complaints against them being subjected to criminal proceedings. The Attorney General, in writing, indicated to the Commission that it has not got a mandate to entertain such complaints. Now, that objection of the Attorney General may be right, may be wrong. I don't want to go into that. Whatever the case might be, if one looks at it from the point of view of the rule of law, the Commission required to first and foremost make a ruling on the matter. That is what you expect even in a domestic disciplinary inquiry. But what does the Commission do? It does not overrule the objection. It does not accept the objection. It does something much worse than either of those two. It simply ignores it and goes ahead doing what it wants to do. What happened then? Summons were issued to various people, some of them in languages that were neither their first nor second language, which is in violation of their language rights, their right to equality, and it undermines also the principles of natural justice. Conflicts of interest that were raised before the Commission. One of the assistant superintendents of police raised an issue of conflict of interest where the retired Inspector General of Police, who was a member of the Commission, was concerned on the basis that when he was the chief of the police force, he had exerted undue pressure. That was the allegation. He had exerted undue pressure on this particular assistant superintendent of police to withdraw or to pull back on certain criminal proceedings or investigations. Now, if there was a dispute in that way, there's a proprietary concern that arises as to whether that commissioner should continue to hear that matter or whether he should recuse himself or some arrangement needs to be made to remove him from that setting. But what happens? That objection is neither upheld nor rejected. It is simply ignored and the Commission goes on to do what it does. Then it gets worse. The Commission chairman from time to time engaged in, I'm sorry, I couldn't find a kind of phrase with which to describe it, although I have tried, I looked, but engaged in a media circus, going before cameras, the media, the press, saying that various persons, various parties were evading the Commission of Inquiry and so on. But that is not the way in which an inquiring officer who dispassionately, objectively goes into allegations conducts himself. Instead, what happened was that he became embroiled in a quest to demonize certain people against whom certain allegations were made. And in fact, the fact of the matter is that at the end of the proceedings, certain findings of culpability were made against numerous persons who were not given notice of what the allegations against them were and allowed to meet that case if there were any allegations. And no opportunity was given for them to present their case. Now, at the very rudimentary level, even at a domestic disciplinary inquiry, one would say that the procedure is flawed at the root. This is a Commission of Inquiry going into matters of great national importance, if you look at the subject matter. So when there is a finding based on such a flawed procedure, one must then consider what must flow from it. The report is submitted to the President, and what follows after that? If there is a finding of this nature, generally, one would get the necessary legal advice and discover that there are serious flaws and there are houses that can be renovated and there are those that just cannot because the foundations are too weak. So in this situation, I would submit that for the reasons I highlighted, there was nothing that could be taken from this commission. But instead, what happens? A presidential commission of inquiry is appointed under the special presidential commissions of inquiry law, which is a more powerful law, appointing members of the judiciary to animate it. I do not fault the members of the judiciary for being appointed to that role because the constitution allows for it, the law allows it. I do not agree with the law. I think it needs to be amended, but that's a different matter. Be that as it may, whatever that the desirability of it may be, what is the mandate that this Presidential Commission of Inquiry is given? To see how to implement the recommendations of this fatally flawed, grotesque Commission of Inquiry report. Now, that elicits a design. This is not a process of inquiry designed to bring out the truth on which the relevant statutory legal actors and animators of the legal and judicial system could be activated and take action to bring to book anyone who may have fallen foul of the straight and narrow or deviated from the straight and narrow. This is evidently a process of political witch hunt on the basis of very obvious facts. So in that context, one has to consider what the recommendations are that the Commission of Inquiry has given, and that itself gives rise to serious concerns. One of the recommendations is that accused who are facing trial in the magistrate's court should be discharged from those proceedings. The Commission of Inquiry goes into complaints, hears a few people, doesn't even engage in full exercise of or does not extend the full rights of natural justice, and decides that those accused of crimes and being charged in the magistrate's court must be discharged. And then not only that, there's also a finding that those who are under indictment in the High Court, that is after the Attorney General has assessed the evidence and decided on action to be taken, some of those involve a trial at bar. What do they recommend? That the acquitted should be discharged and that indictments should be withdrawn by the Attorney General. It gets worse. The officers of the Attorney General who prosecuted in some of these cases, as well as members of the private bar who represented the interests of concerned and affected parties, they say must be dealt with for fabricating false evidence and that they must be prosecuted by the Bribery Commission for corruption. Now, this is a serious encroachment on the rights of the legal profession to practice. And if this trend is allowed, there will be no safe system of adjudication because people might tend to take a back foot. So this is something that requires to be addressed and something that requires to be taken on. In respect of a concluded quadruple murder case in the High Court, the conviction of which withstood the test of a Supreme Court appeal, the final appeal. The Supreme Court of the country is the highest and final court of appeal in the country. It has held that the conviction was sound. And what does this Commission of Inquiry, consisting of 2 retired judges and 1 retired police officer, say? That the Attorney General must reopen the case and move to discharge the accused. This is the nature of the findings and recommendations that are sought to be enforced, embroiling in the process members of the judiciary who are appointed to a Presidential Commission of Inquiry. This is not a situation that is satisfactory, and in my view, it is something that the bar and all those who are concerned with the proper and smooth functioning of the legal and judicial system must take serious issue with and take head on. Now, what are the consequences if the Special Presidential Commission of Inquiry were to go into the matter and implement the recommendations that have been made by this Commission of Inquiry? I don't have the time to go in depth into all the recommendations made, but let me summarize it by saying that what it means is that upon the Special Presidential Commission of Inquiry arriving at findings adverse to the persons named, those persons include members of Parliament who raise an effective voice against the powers that be, and that is an important part of democracy. They include renowned, respected members of the bar, including Dr. Jayampati Vikramaratne, President's Counsel, one of our top constitutional lawyers, J.C. Valyamuna, President's Counsel, who has been a leading civil rights lawyer for decades now and has been a leader of the bar in that sphere. It includes them, and it includes members of the police force and the civil service. There are recommendations that the MPs concerned, if the recommendations are upheld and there's a finding by the Special Presidential Commission of Inquiry, in line with apparent expectations, the MPs would lose their rights and those whom they represent in Parliament will lose their voice. Their franchise will be snuffed out because the government at present has a 2/3 majority and can pass the requisite resolution to do so. The lawyers concerned, their right to practice and their civic rights would be affected. This will be a deterrent to a free and independent bar, which must be resisted. In respect of certain recommendations, the right of certain people to even hold property can be taken away. And of course, the basic right even to participate in democracy by casting a vote at an election can be taken away. All of this, not for 6 months or a year, but for up to 7 years by law. All this weakens the rule of law and smacks of authoritarianism. And authoritarianism, I would submit in the strongest of terms, finds no home where there is rule of law. So in this context, all of these issues are going to be adjudicated at some point and issues will be raised. And this is why such issues and all of the very salient concerns that were raised by the eminent speakers before me, such as Ambika and Shreen, will eventually end up, when all else fails, people can make representations, people can protest, they can stand on their head, but when all else fails, where can the person who does not have the strength of majority and strength in numbers in the sense of electoral democracy go to? They can only go to court. And therefore, if there is no free and independent judiciary, there is no hope of democracy for such people. So that is why different aspects of the functioning of the judiciary and their appointment, their promotions, and so on and so forth, and the power of removal become very important. I will touch very briefly on the method of appointment of superior court judges, because it is superior court judges who basically hear cases of judicial review involving executive and administrative action. It is the Supreme Court that interprets the Constitution and vets draft legislation for inconsistencies with the Constitution if there's a challenge mounted. And so the superior courts are pivotal in upholding the rule of law where executive and administrative action is concerned. Now, the appointment process after the 20th Amendment, which was passed in September of last year, centralizes the decision-making power in one person, the president, whoever he or she at a given time might be. The president is able to take a decision as to whom to appoint. It is whomsoever the president deems suitable for the purpose. And I use that phrase, which is not to say that all judges who are appointed in that way are bad. That is certainly not the case. There are judges who will do the right thing because that is what they want to do. But what I'm saying is that the assurance of the rule of law is not dependent on the goodness of people in shaky, weak systems. The assurance of the rule of law resides where there is systemic protection that makes for independence of people and does not require Herculean strength to uphold basic standards and tenets of justice, fair play, and equality. And for that, there is no way in which the required assurance can be given when the president decides, as a matter of law, only ascertaining the views of a parliamentary council. The parliamentary council consists of the speaker, the prime minister, the leader of the opposition, and 2 members of parliament nominated by the prime minister and leader of the opposition, all parliamentarians dominated by the governing party, which constitutes the cabinet, and it's from the same party that the president also is. That's the current dynamic. So that in any event, it is not a check and a balance, unlike in the case of the 19th Amendment, where there was a check in the form of approval required of the nomination given by the president. There is no ability to veto, even with very good ground, a selection made by the president. So that is no check and balance. Even as far as the ascertainment of views is concerned, there is no provision even to ascertain the views of civil society. One must not be swayed by the misconception that the views of all society are represented by those who are elected to parliament. Parliamentary democracy and electoral democracy has inherent limitations which cannot be helped in any jurisdiction. It is only those who can muster sufficient electoral strength that find direct voice for those causes that matter to them the most within an elected legislature. That is a reality one must live with in any society. But there are those who belong to communities and groups, individuals who don't have strength of numbers, but have distinct identities, have distinct specific concerns, and have individual rights of particular interest to them that can only be upheld if it affects their basic rights and dignity as a human being, if they can take it before a judge or judges who will be alive to their rights, irrespective of the impulses of dominating parties, be they in government or in the mainstream opposition. That is why the inclusion of a civil society voice is essential in order to be able to ensure that the selection process of appointment of judges ensures that the concerns of all society, after all, a judge must be able to uphold the rights of a single individual when everyone else in the population feels that that right must be denied, if that is what the Constitution and the rule of law requires. And for that to be done, this process must change, and there has to be brought in a system that has checks and balances on the power of appointment. Then the aspect of removal. Our keynote speaker touched on the gory episode of the exclusion from office of the 43rd Chief Justice, Dr. Shirani Bandaranayake. After that experience, where a select committee was appointed, which basically of Parliament, which basically insulted her in obscene language to the point where she couldn't handle it anymore, she just walked out, as did the members of Parliament who were in the select committee, who did not belong to the ruling coalition at the time, because they couldn't handle how disgusting the proceedings were. In her absence and without their participation, a finding was of so-called guilt was arrived at, and she was excluded from office. Consequent to that experience, when the new standing orders were brought in March of 2018, it's effective from 15th of April 2018, provision was made for another process by which, if a judge is to be removed on the basis of proven misbehavior or incapacity, there has to be a process of inquiry contemplated by the standing orders of Parliament. This requires the Speaker, in consultation with the Prime Minister and the Leader of the Opposition, to appoint 3 retired Supreme Court judges who will go into the matter and within 2 months arrive at a finding. They can ask for an extension, the panel of judges can ask for a month at a time if necessary, and they can basically arrive at a finding. Only if they arrive at a finding can Parliament proceed to make an address for the removal of the judge concerned, and only upon that address can the President remove a judge. Now, this is a salutary improvement, I must say, and that is welcome. However, all is not well as one might seem, because there is a hitch that has not been tackled. The standing orders provide that the panel which conducts this inquiry, the panel of retired Supreme Court judges appointed by the Speaker, must conduct its inquiry in a manner that will be prescribed by law. Now, law is defined in Article 170 of the Constitution as meaning nothing else and nothing less than an act of Parliament. To date, no law has been passed by which there is provision, clear provision, that ensures that such a panel can conduct its affairs. So, if an issue arises, I dare say, if a judge acts independently in a manner that annoys the President or the executive that is in power at a given time, right now, an issue can be raised as to whether such a panel can function. And then what if at that time it is sought to pass a law? I would say that that is not the time at which a law must be passed. Because if a law of that nature is passed when there is an impeachment in the horizon, it will necessarily be ad hominem. The legislators, the executive being formed from the party that commands the majority in the legislature will also therefore, as a majority which prevails, look at it as in an ad hominem way. So there may be features, or there are bound to be features that are inimical to the due protection of the rights of the judge concerned. And if it is challenged when it is in draft form in the Supreme Court, what will happen is when the Supreme Court arrives at a finding of consistency or inconsistency, both ways I will add, there can be allegations and perceptions as to why the judges arrived at it that way, because there is a live issue that affects the rights of the judiciary and distinct individuals who constitute the higher judiciary. And there will be the question, at least, as to whether the judges held the way they did because of their disposition to the particular issue or the particular judge concerned. Now, that is an embarrassment, and that is an unfortunate situation that the government must take care to avoid. It is not good for the judiciary. It is not good for the executive either. In fact, it is not good for the legal and judicial system or the people of this country. So there has to be a push for an immediate passage of a proper balanced law that provides safeguards against arbitrary and improper removal of a sitting superior court judge. There are numerous other aspects that I could touch on, but I'm aware of the constraints of time. So I will conclude my brief presentation with those words. Thank you very much for the opportunity.
Thank you, Viran, for making such an exhaustive but precise presentation, bringing all the concerns and challenges on the table. And also that, in terms of removal, what are the safeguards which must be brought into play? Though, looking at already the dilution which in terms of appointment has taken place, how much that hope can be on firm grounds is something to be discerned. But at the same time, it appears to me a very pernicious device that you empower retired judges who are discharged of the oath of office under the Constitution. And then they sit on a kind of a review of final and binding judicial orders and judgments, taking them out of the hierarchy of the normal judicial process, and then placing it before the sitting members of the judiciary, though there is a provision in the Constitution, as you have indicated, as a presidential commission. But I understand that commission should be having more of an advisory jurisdiction rather than a jurisdiction which can annul or which can set aside the orders passed in the normal judicial process. So how can an advisory jurisdiction and a device through the fact-finding device of a commission of inquiry, all this process is outside of the Constitution and the principles of rule of law. So that, I'm not going into the facts, I'm going into the legal mechanism. The facts may be debatable, and that's what you are bringing on the table. There may be facts from the other side also. But what concerns LAWASIA, what concerns members of the legal community are the very processes which are seen as sacrosanct, which are being subverted clearly and openly. So that is what brings us to our next presentation. My good friend, Geoffrey Agalaga-Ratnam, PC, President's Council. I hope the presidents keep the counsel of such councils. Then most of the issues which we are facing today won't arise. So even the word President's Council should be given a substantive meaning. So Geoffrey has been the president of the Bar Association of Sri Lanka for 2015-16 and 2016-17. That is the time when LAWASIA held its Golden Jubilee conference in Sri Lanka. We had come there with the hope to celebrate the rule of law. And we are now 4 to 5 years from that. We are facing these challenges. It's personally, for me, what change has taken place does not gladden anyone's hearts. It is not a political question. It is purely a question of the rule of law and the institutions of rule of law, how they function. Now, of course, he has a very illustrious career as a litigator in various fields and appellate and original jurisdiction before courts in Sri Lanka, specializing in industrial, corporate banking, and intellectual property law, and engages in advisory practice in industrial and commercial transactions and others. He also practices before statutory authorities, bodies, and commercial arbitration tribunals, and taken a keen interest in the areas of public law and is actively involved in public interest litigation and issues of public interest, a role which he is going to play here through his presentation to bring the public interest of the citizens of Sri Lanka as an illustrious member of the bar, as its past leader. And so far, Geoffrey and everybody, more or less, we have been proud of our colleagues from Sri Lanka because there have been individuals consistently who have stood up to the power, who have stood up for the rule of law. And that is how these concerns, because LAWASIA has a process, it is the member body, it is the members who bring the issues to the table. And then LAWASIA, by organizing this kind of an award, creates an international public opinion and understanding surrounding the issues. So, Geoffrey, it will be a delight to have your presentation, as it has been a big delight so far to hear each one of you. And I'm sure the participants will agree with me wholeheartedly. There's a struggle to get heard by the defenders of rule of law.
I know it's been a constant struggle. Sorry about that. Thank you, Prasant. Thank you, LAWASIA. Well, I would like to emphasize the role of the bar. The bar is in a very enviable position. That is what we have always failed to realize. The bar is the important interface between all the organs of government and civil society. The bar is something that is a leader amongst other professions. People look up to the bar to show what is right, what should be done, and what should. The bar should be a beacon, and the bar should show the way to the people, to the government, as well as to the judiciary. The bar has to be a protector of the rule. We always fail to realize is that one of the major organs of government is the court system, the judiciary. But we also fail to realize, as Viran just mentioned, that we are officers of court. Whether you have the official bar, the Attorney General, you have judges, but what we should realize is that without the official bar functioning in a court of law, there is no court. That is why you take a simple example. When we sit in courts, and sometimes the judge is all alone once he's finished the work of the day and he's just finalizing his paperwork, we do not exit from the court. and leave the court empty at the bar table, because the absence of the bar makes the court deficient. And so one should realize that the bar has a very important role to play, and that should be on the conscience of the bar. I need not say that in the recent past, the bar has not lived up to its expectations. And I'm not trying to say that everything has been good right throughout. There have been aberrations. But the tendency today for the bar is that there is a lack of objectivity. And there is, I would say, growing politicization of the bar. Take the recent elections. There was campaigning on political lines. One of the allegations was if one of the candidates is being supported because the party has decided to support him. Another allegation was if one of the candidates is elected, the country cannot be properly administered. I don't see what relevance the election to the bar could have to the administration of the country. Of course, I have always held the view that the bar should not be anti-government. It should support the government in all its endeavors, provided they are rational, reasonable, and in the rule of law. But it should be able to stand up constructively and with dignity against any aberrations. And that, I see, is lacking, especially in the last few years. Take, for example, the case of Hijaz Hizbullah, who was arrested in various funny circumstances, accused of link with the Easter Sunday bombing, and said to be a person who was intimately involved in arms strike. All those allegations are there. A person is innocent till proven guilty. But the manner in which he was taken into custody, kept in custody, incognito or incommunicado, was something that many lawyers objected to. They sent a petition. But it also happened that there were rival petitions taken up to outnumber the number of signatories who protested at the failure of the due process. We were not trying to say that Hijaz Hizbullah is innocent. All we were saying was follow the due process. And there were a rival petition by the powers that be who got signatories to outnumber the number of signatures on the petitions that lodged the objection with the bar. The bar came out with a very curious explanation, but not taking the matter further, by saying, we feel the people who are objecting to his incarceration have some ulterior motive. Every one of us has motives. Every one of us has reasons, but one has to be objective. And I would say, if the bar doesn't fulfill its functions, we can forget about the rule of law, because it's the bar that guides the country more than any other profession, whether you take it the doctors or the citizens. And for this, I would also confess that I cannot condemn the bar as a majority, because if you look at the outcome of the recent elections, man to a man, the bar knows what is right. Perhaps some of the right-thinking people remain silent and the majority goes by default. And perhaps some of the seniors who should lead the bar are reluctant for various reasons. Perhaps they are in their comfort zone. But I must say that the bar as a whole can be independent, but not assertive enough. That is the problem. Viran was talking about appointments to the judiciary. The bar in the past has taken up the position of suitable persons being appointed to the judiciary. Because what we must know, that especially appointments to the higher judiciary is something that is not a mere promotion. You don't go there by effluxion of time because you have been a career judge or anything else. You have to have the most suitable people. So these are some of the matters that the bar has been engaging the judiciary. And the bar should realize that it is an equal player with the judiciary. And if it doesn't realize that role, it is failing. It is not a case where the judiciary is a specially exclusive privilege enclave, which dispenses justice and nobody else has a say in it. The official bar and the unofficial bar, I dare say, are equal strategic partners in ensuring the rule of law. And the test is, have we failed? Do we live up to our expectations? The bar is not a thing, okay, it's our bread and butter. But we fail to realize it's not a mere job. It's not a mere business where we make profits and make lots of money and wear our silk ties and drive our Mercedes-Benz cars along. It is something where we have to serve. Any profession has to serve its competency and rectitude. We are governed by rules of ethics. So maybe there are not many people who are interested in constitutionalism, the rule of law, but at least the leadership and the bar should be conscious. One of our principal roles are to uphold the rule of law, which speaks a lot. The Bar Association has a constitution of 1974, and to look after the welfare of the lawyers. The bar cannot be performing a mere welfare function to give lawyers free books, free buffet dinners, free weekend parties at the beach resorts for a good opportunity to have a dip in the sea. We have to develop the members of the bar. We fail to realize that we've got about 14 to 15,000 persons scattered all over the island as members of our bar, which is a very powerful organization. It's a voice that cuts across the entirety of Sri Lanka. Can we think uniformly on the key issues? It's a bit disappointing these days because there's too much politicization. One could say, if there are cases involving two political parties, one could predict who the lawyers will be for either side. There are objective seniors who will appear for a worthy cause. But in the past, we had giants. We had giants. We had people like R.K.W. Gurusekara, H.L.D. Silva. They had their political affiliations. But when it came to the profession, the bar, the rule of law, they would take on any cause, no matter which party or political affiliation the victim is attached to. In fact, I have heard that one of the common boasts of one of our great constitutional lawyers, Nadesan QC, was that, he used to proudly say that I know what he meant by it. I have fought every government in power. What he means is on a matter of principle, not because he has been just an anti-government cantankerous guy. There was no reluctance to take on an issue. And that is why the bar has to be more united. Because if the bar is united, it's not only the government, even the judiciary would be careful. Because we have, who is going to guard the guards? If you have an aberrant judiciary, who is going to stand between that aberrant judiciary and the citizens and their rights? It's the bar. You find Viran talking of the Commission of Inquiries Act and how retired judges, this is something which should not be desirable, are appointed and they are overseeing judicial activity or judicial processes. I mean, that type of thing is something unimaginable. And who is going to make sure that, for example, the Attorney General's office, according to this commission's report, have preferred politically oriented cases against people. And they have been victimized because all the prosecutions, a lot of the prosecutions are by the Attorney General. So this commission report is a serious indictment on the Attorney General and his impartiality. Now they're saying, Attorney General, you review your own charge sheets. You set aside your own convictions that you have secured because this is political victimization. If this is not an insult to the official bar, what is? Shouldn't the bar stand up to this? And hasn't the bar got to protect the office of the Attorney General? Of course, it's an entirely different aspect as to whether the office of the Attorney General is accused of being politicized or under political pressure. That is where we have always, as the bar, asked for a director of public prosecutions, who should be an independent person, who doesn't get too intimately involved with the powers that be and is not subject to their manipulations, but who prefers his prosecutions independently, objectively, so that there cannot be commissions later talking of cases criminal being prosecuted and convicted for political victimization. So these are serious matters. So my point of emphasis is that the bar has failed in the recent past to be proactive enough, to be assertive enough. The bar cannot afford to be divided on political lines. In fact, you had the unfortunate feature which has existed over 40 years of having what you call party lawyers. There's a special team of party lawyers for every party. And when one party goes out of power and the other party comes in, those guys are preferred for cases, to handle cases of public corporations. They are paid money. They don't have to pay pro deo. So these political affiliations is not only sometimes a matter of principle, it is a matter of having positions and earning money at the expense of the state, not at the expense of the government. It's the public taxpayers' money. So when you look at the way the bar has been politicized, this is a matter for regret. And therefore, I mean, we have had people who are very strong supporters of political parties. But when it comes to the rule of law, we stand together, say, no, whoever you may be, you cannot do this. And the bar has also been very strong and assertive, even in the case of if there are errant judges. So the pivotal and crucial role is that of the bar. And I must say that we have got to look at these things very seriously. Otherwise, if the bar fails to do so, it is failing in its responsibility, not only the rule of law, it's failing in its responsibility to the citizens and society to show the right way, to be a beacon. It is failing in its responsibility to protect as well as call the judiciary to accountability. Because there's no point criticizing judges and saying they are not independent, they are weak, they are corrupt, they are politically appointed. What has the bar been doing about it? So I think we have to say a big mea culpa. And if we don't get our act in order, this slide in democracy, this slide in rule of law, because what else can a government do? Unfortunately, it only feathers its own nest, looks at its own agenda, and that is the weakness of all. As someone says, you can test a man's valor by giving him adversity. If you want to test a man's integrity, you give him power. Many people fail this test. So these are the important aspects that I would like to emphasize from the point of the rule of law. In fact, it was your Indian Chief Justice, Prasant, some time ago, who said, the bar should realize that it is an essential cog in the wheel of justice. The bar, the unofficial bar. Just because we are called unofficial doesn't mean we are a set of private guys who are making money at the cost of our clients, maybe throttling them financially. But we have to realize that there is a social responsibility. There's a dimension which affects the rule of law, which affects the judiciary, and which has to be some sort of a force between abuse of power and the proper adjudication of matters. So since my good friend Viran also has touched on various aspects of judicial independence and wrong appointments, I will not go into those details. But from my point of perspective, I think that the bar has a very critical role to play. And it has much more to do. In the recent past, it could have done much better. I'm not saying that the bar has always been at its epitome in upholding the rule of law, but there has been a steady slide in the last few years. And I think it's important that some of the seniors who are non-compromised and not seen as partisan, whether it be on political or racial lines, should get together and send a signal to everyone, whether it be the judiciary or the government, that our country is at stake. Our country is at stake if the rule of law is not upheld. Thank you.
Thank you, Geoffrey. Cannot agree less with you. Whatever you have said about the bar, LAWASIA has bar organizations as its organization members. And one of the messages this webinar sends is that with each member bar, when it comes to the challenges faced on rule of law front, LAWASIA stands with it, stands by it. And the support of the international legal profession while facing these challenges is material, has had some impact in the past, and does make a difference. This is what LAWASIA believes. Now, the discussions have been very serious, but just to break that chain a little, and again going by that, you yourself highlighted party lawyers. So there is a difference between the definition of President's Counsel, one which is a literal and one which is substantive. And then again, bar is of two kinds: the bar which is drunk on the portion of rule of law, and the socializing bar, which wants to smoosh with those who are presently in power. So we will rather prefer the bar which is drunk on the portion of law, and LAWASIA stands with that, segment of the bar. And we wish Bar Association of Sri Lanka and all our colleagues all the strength and all the good wishes and all the support which we can give from LAWASIA to face the challenges which are there in Sri Lanka. Now, our last speaker, and again, since he is from UK, and due to the time zone, it's a video recorded presentation of Mr. Zimran Samuel. He is a Bar Human Rights Committee member of Law Society of England and Wales, and belongs also to the Doughty Street Chambers. He has worked in a wide-ranging practice based around children law, mental capacity proceedings, and international law. And he has worked with the Office of Legal Affairs at the United Nations headquarters in New York. So he is a young barrister, and he brings fresh and vibrant, but relevant and serious perspective on the table as well. So.
It is a huge pleasure to be asked by LAWASIA to participate in today's international conference on the rule of law, justice and democratic rights in Sri Lanka. And it is a pleasure to be speaking on behalf of the Bar Human Rights Committee of England and Wales, the BHRC. The BHRC is the international human rights arm of the Bar of England and Wales, and we are an independent body of legal practitioners who work to protect the rights of advocates and judges and internationally recognized standards relating to human rights and the right to a fair trial. The BHRC has worked in Asia for many years and has been involved with amicus curiae submissions, statements, interventions, trial observations, legal training, including in India, Pakistan, Nepal, and Sri Lanka. As reflected in our most recent work and statements, the BHRC remains concerned with the deterioration of the rule of law in the region, including in India, Myanmar, and China. And we call for sustained international efforts to restore respect for fundamental human rights. We have raised awareness in relation to accountability in Sri Lanka, including the persecution of lawyers on a number of occasions in recent years. The BHRC has called for accountability for past human rights violations, including through domestic mechanisms. We issued a statement jointly with the International Bar Association's Human Rights Institute in an attempt to persuade and influence proceedings at the recent 46th session of the UN Human Rights Council, because we are gravely concerned at the deteriorating situation. Following on from the 46th session of the UN Human Rights Council, we strongly believe that an international accountability mechanism to monitor and report on human rights in Sri Lanka is necessary, in addition to the collection and preservation of evidence. In particular, our concerns centre not only on the ongoing lack of accountability for past human rights violations, but also the credible reports of interference with judicial processes and judicial independence, the arbitrary restriction of lawyers seeking to promote human rights, and the promotion of discriminatory policies against minority groups. These have all been reported in the last year. The BHRC relies in its analysis on reports from international bodies such as the United Nations, Amnesty International, and Human Rights Watch, as well as lawyers on the ground who are witnesses to, for example, interference with judicial independence and restrictions on and arbitrary detention of lawyers. In February 2020, the President withdrew from Sri Lanka's commitment pursuant to the UN Human Rights Council Resolution 30-1 to investigate violations of international humanitarian law and hold war crimes trials with the participation of international judges, prosecutors, and investigators. The UN High Commissioner for Human Rights reports on a culture of impunity whereby the cases that did reach the courts were subject to repeated delays, interference, harassment of victims and witnesses, and only exceptionally achieving convictions. Since that time, the accountability process for past crimes continues to be systematically undermined by the current government, which has proactively obstructed ongoing investigations and criminal trials. Some of the key points that we wish to highlight are the following. Firstly, since last year, the President has appointed at least 28 serving or former military and intelligence personnel to key administrative posts and has formed several presidential task forces with vague, overbroad, overlapping mandates with existing institutions. We share the UN High Commissioner's alarm that these appointments include senior military officials who, in the UN reports, have been alleged to be implicated in war crimes and crimes against humanity during the final years of the conflict. On the 9th of January last year, the government appointed a presidential commission of inquiry to investigate alleged political victimization of public officials, members of the armed forces and police, employees of state corporations by the previous government. With its broad mandate, the Commission has intervened in police investigations and court processes, undermining the police and judiciary in several high-profile human rights and corruption-related cases. Hundreds of officials involved in trying to prosecute human rights cases involving state officials have been targeted. More than 700 law enforcement officials with the Criminal Investigation Division, the CID, who investigate human rights violations, were placed on a travel ban soon after this government came into power in November 2019. CID Inspector Nishanta Silva left Sri Lanka in 2019, fearing reprisals for his lead investigative role in respect of several such cases, and since then he has been charged with various offences. In July last year, Shani Abisekara, a former chief of police who led investigations into several high-profile crimes and emblematic human rights cases, was arrested on spurious charges for fabricating evidence in a murder case. And on the 22nd of October last year, Parliament passed the 20th Amendment to the Constitution, changing the balance of power between the different branches of the government. The amendment has fundamentally eroded the independence of key commissions, such as the Human Rights Commission, and institutions, including the judiciary, in terms of procedure for selection, appointment, and dismissal of senior judges and other high-ranking officials. We are also concerned about the targeting and discrimination against minorities. Muslim communities are facing increasing hostility after the Easter 29 bombings, and Michelle Bachelet has recorded the increasing levels of hate speech and security and policy measures that appear to be discriminatory and disproportionately directed against minorities, both Tamil and Muslim. This has been addressed by the resolution of the UN Human Rights Council at the 46th session. And finally, the Prevention of Terrorism Act has been repeatedly used to sanction arbitrary detention and remove safeguards against the torture of detainees. This law was used to detain Hijaz Hezbollah, a prominent Muslim lawyer, and the BHRC issued a statement at the time in support of Mr. Hezbollah, which is available to view still on our website. The likelihood is, and which we have to acknowledge, is that war crimes and crimes against humanity were committed by both sides. A special hybrid court, including international judges, prosecutors, lawyers, and investigators, remains an essential step towards justice and reflects the agreement reached in Resolution 30-1. At its 46th session, the UN Human Rights Council stressed, in its final resolution, the importance of a comprehensive process for all violations and abuses of human rights committed in Sri Lanka by all parties. The 46th session of the Human Rights Council heard of serious concerns at the trends emerging over the past year, which represent a clear early warning sign of the situation in Sri Lanka. Yet, on the 9th of April this year, the government is reported to have moved directly to interfere in matters before the judiciary. The Prime Minister has tabled a resolution in Parliament that seeks legislative approval to end trials against several family members indicted for corruption and military officials accused of murder and abduction. The resolution sought to end trials currently underway in the courts against a former Navy chief and other high-ranking naval officers indicted for the conspiracy to abduct and murder 11 Tamil youths in the 2008-2009 period. So in conclusion, the BHRC joins LAWASIA and bar associations across the world in calling the government of Sri Lanka to ensure prompt and thorough impartial investigations for serious violations of international humanitarian law. Thank you very much.
Thank you, Zimran. Though this was a recorded presentation, I can't thank you in person, but it was a well-researched presentation with facts and figures to round off the current webinar. Friends, unfortunately, we have already run almost 1 hour beyond the time limit set, but as a moderator, with the kind of gravitas of the issue and each presentation brought forward, limiting time would have been doing injustice to the substance of each presentation, which has been so relevant. So now, by way of Q&A, I am perforce limiting it to only 2 questions. The rest can be responded in writing. So because of the constraints of time, and also a panel discussion is not possible, but I think we have had mostly all the perspectives covered. So I am, one always should hear a point of view from the other side. And I'm placing this question from my old colleague and friend. He's not old, but has been a very old colleague at LAWASIA from Sri Lanka, Mr. Sunil Aberatne. He is saying you are trying to interpret safety of Sri Lanka as a war crime. LTTE must be responsible for actual war crime here. What are the steps you have taken against them? So I will put this question to Ambika to answer.
Thanks, Prashant. Well, I think no one is actually saying that national security should be jeopardized, but there are international standards that you have to abide by, even when you take measures to protect national security. Particularly in relation to internal armed conflict, there is humanitarian law. And much of this law related to even non-international armed conflict is now customary law, which means it applies all countries, whether you have signed up to additional protocol 2. So there is that. But in terms of the practical, the question that you asked, I think there is also a lot of disinformation, false information out there that the UN and the international community has not taken note of violations by the LTTE. If you look at any of the reports by the UN, whether it is the UN Secretary General's panel of experts, or whether the OISL report by the Office of the High Commissioner for Human Rights, all of them set out in extreme detail also the violations by the LTTE. In terms of prosecutions, if you look at internationally, whether it's Germany, whether it's the United States or the United Kingdom, in their own national jurisdictions, they have prosecuted persons and convicted them for various activities related to the LTTE or being part of it, raising funds, etc. So I think it's a myth, not just a myth, but also false to state that it has not been paid attention to. And my last point and most important one is, if you wish to prosecute people for LTT's violations, well, there are two persons who are currently part of the government. One who is also supposedly responsible for the massacre of 600 policemen in Sri Lanka, Karuna Amman and Pillian. Now, these people are part of the government, so if we wish to see accountability for LTT violations, we can start right there.
Thank you, Ambika. And now we have a question from Avi Salvaraja. That is, what are the obstacles facing Tamil rights litigation on the island, particularly if there has been a shift in the court's post-Rajpaksha return, and are lawyers facing reprisals for being counsel on these cases? So, Geoffrey, would you like to answer this?
Thank you. Two aspects to it. When you talk of minority rights, it's not particularly with this government. There is a fairly well-researched book by Jayanta Almeida Gunaratna, Kishali Pinto Jayawardena, and Gihan Gunatileka, which shows the subconscious judicial mind. And it addresses it to mean that not consciously, but at least subconsciously, minority rights have failed to be protected by the judiciary itself. Okay. So that's why I say the bar is very critical in ensuring that judges, suitable judges are there, because we also have very often the allegation when you have higher judiciary appointments from the official bar, that those judges tend to be statish, pro-institution. They come with certain blinds. So there is a lot that has to be done from the point of the judiciary to have an open, unbiased mind and to realize that this is a multicultural, multi-religious society we are talking about. And as you mentioned, there cannot be majoritarianism. Democracy is not majoritarianism. It's accommodating the views of all. And we have got a long way to go there. And that is where civil rights society, the bar, have to be very strong on the fact that it's not merely a constitutional guarantee of equality, but there should be laws in place. Attitudinal change is needed from the profession, from the judges, and even the official bar, that everybody is Sri Lanka. Unless that attitudinal change has to come, because since 42 years of independence, barring perhaps two of our rulers, everybody has had a racist streak, they say. And everybody has played into majoritarianism and cultivated it and nurtured it. So where do we change it? The responsibility is more on the bar and on civil society.
Thank you, Geoffrey. And with this, let me thank, on behalf of LAWASIA, each one of our eminent panelists, all those who have sent in questions which will be answered in writing. Our panelists can give them to Secretariat and they can be provided to the participants. And all the participants, most essentially, who have been here for almost 2.5 hours to listen to all of our eminent panelists. And I hope you must be leaving with a sense of being much more well-informed about the situation in Sri Lanka. And last not but the least, let me thank the LAWASIA Secretariat, which has put together all this wonderful webinar run through the practice sessions, seeing to it everything goes on smoothly. The team of Shana, Magda Imre, Ria Singh, and others. And not the least, the LAWASIA Executive Committee and in charge of devising the program, the Human Rights Section led by Shyam Diwan and Yasushi from Japan, and Stephen Tiru, and all others who have been instrumental in putting this webinar together. And I thank you all for extending this wonderful cooperation. Please remain tuned to LAWASIA events, visit LAWASIA's websites, get engaged with LAWASIA by joining it. It's a regional organization which promotes the rule of law with Asian sensibilities and understanding of the region, which is more intensive than anybody else. And we are always making that effort with the help of all of you. So with this, we sign off. Thank you very much. Be safe, especially in the light of COVID. In India, the circumstances are dire, but repeat waves can come. India's example shows that. So I pray for good health, safety of all of you. Please take care, stay safe, stay healthy, stay happy. Thank you.